Yeah, he said.
Good evening to all our esteemed dignitaries and participants present here virtually. I, Vedant Vaishali Jayant Mainkar, have a great honor as a moderate this valedictory session for the virtual summit on gender data and technology on behalf of Maharashtra National Law University, Mumbai. This summit themed gender, data, and technology has been a collaborative effort brought to fruition by Maharashtra National Law University, Mumbai, with invaluable support from Jindal Global Law School, Center for Women's Rights, and MIT Dubai, serving as our esteemed knowledge partners. Together, we have embarked on a journey to explore and address the intricacies, intersectionalities of gender, data, and technology in these 2 days session. Throughout the course of this summit, we have engaged in enriching discussions, exchanged insightful perspectives, and dwelled deep into the complexities surrounding the gender, data, and technology. We have confronted challenges, shared innovation solutions, and envisioned future where technology is not only gender inclusive, but also empowers individuals and all genders. As we come to close this summit, it is imperative that we reflect on the significance of the conversations we have had and the actions we must take moving forward. The issues of gender equality, data, privacy, technology, advancement are not mere topics of discussion, but pressing realities that shape the fabric of our society. It is our collective responsibility to ensure that these discussions translate into tangible actions that drive positive changes. I proudly say that this Gender Data Technology Virtual Summit, which had for 2 days, there were around 200 abstracts which we received as research papers. Of 200 abstracts, around 50 were selected, of which around 20 were of professionals and others were from students from various NLUs, various other universities. And we also had some students joining internationally from Bangladesh, Malaysia, and Thailand as well. It is a proud moment to say we had announced this in our inaugural session also. We have compiled our abstract booklet of all the students, the selected abstracts, and this abstract booklet shall be available on Amazon as a book, which we can purchase very soon. So I hope the participants enjoyed this 2 days and had a rich enrichment of knowledge and had diverse perspectives on gender, data, and technology, where we had sessions on gender sensitivity, disruptive technologies in AI, cyber security, etc. Today, in this valedictory ceremony, we are honored to have our Attorney General of India, R. Venkatramani sir, and the guest of honor, Ms. Lisa Webley ma'am. With this, I request Dr. Anand Raut, sir, the Nodal Officer of Pro Bono Club, to kindly take over the session.
Yes. Vedant, am I audible?
Yes, sir.
Yes. Thank you, Vedant, for that introduction and for uh, gisting out the things that we did, yes, that we have been doing for last 2 days. Yes, so I and Dr. Garima Pal, on behalf of Maharashtra National Law University, Mumbai, extend our heartfelt gratitude to all of you who are gracing this occasion virtually, this occasion of virtual valedictory ceremony of gender, data, and technology, which was organized also as a commitment to ICSSR funded research project on data protection and localization. For accepting our invitation, I would like to express our sincere thanks to R. Venkatramani, Senior Advocate and Attorney General for India, to be the chief guest, and Professor Lisa Webley, Chair in Legal Education and Research, Birmingham Law School, to be the guest of honor for the program. A special thanks to R. Venkatramani sir, who have been traveling. He had connected us few minutes back, but he's trying to just reconnect. And despite that, he's just trying to take out his valuable time in his busy schedule He has been a proponent of technology. We all know that he has voiced for hybrid hearings across all the courts in India, not just Supreme Court or High Court and the higher courts, but also the lower courts, uh, uh, which can ensure social peace and solace in the country. We also resonate his belief that legal landscape should undergo a change as a whole in order to ensure equality of participation. And any such change must be triggered by education, employment, political process, and global motion. Uh, we hope he reconnects soon. But a special thanks to Lisa ma'am, who has been very regularly on our platform. Whenever we invite her, she's been gracious to accept our invitation. Uh, and she has inspired us through uh, her writings, through her work. A few minutes back, I told her that that some of the participants did refer to her work on adaptive professionalism published in the seminal paper, The Profession's Engagement in the Law Tech Narratives and Archetypes of Future Law. This work emphasizes the complex contextual nature of legal professional field. Through this normative account, she has suggested that the profession may access the benefits of the technological developments while holding on to essential notions of ethical conduct, access to justice, and the rule of law. With this, I would request Professor Lisa, to express her insights, or we'd like to hear from you, Professor Lisa. We have been reading you, but we would like to hear you today.
Thank you. Thank you very much, Professor. And I'm honoured to be invited to participate in this really important summit. Thank you very much. It's terrific to see such a focus on gender, data and technology. I know that there have been many esteemed speakers, and an awful lot of time and energy has been put into what is a complex area, which is increasingly important and which will likely define not just the legal profession, but also the way in which the rule of law is understood by the whole of society in all countries as we start to engage more with different forms of technology. And so I'd like to take just a few minutes. I know your time is very precious and you've had an awful lot to digest during the summit, but a few minutes to think about what it is that we can focus on ourselves as lawyers, whether as law students, as law academics, as practicing lawyers, as judges, as those who advocate for the importance of law, for equality, for justice. What we can focus on when we are thinking about our roles. So your summit obviously has been in the context of the law, gender, data and technology in the context of the law. And the foundation of the law is the rule of law. As we all know, the rule of law provides, even in its thinnest, its narrowest conception, procedural guarantees, which include equality guarantees, guarantees about fairness, about transparency, guarantees about certainty, guarantees about access to a decision maker who is able to judge fairly and objectively whether our rights have been breached, whether we have responsibilities that we must fulfill. And one of the biggest questions we face as lawyers relates to the way in which technology may change our relationship with law, with legal decision making, with accountability, with transparency, with certainty for ourselves and all those we represent, and how it may shape the public's confidence in the legal system. So one such question relates to increased use of algorithms to inform us, to guide us, and in some instances to replace human decision making. Whether those are outside or within legal contexts, they all have, in the end, legal outcomes for people. These technologies and the data that drives them have the potential to provide greater access to justice. There's a huge amount of unmet legal need, and technology is a means by which lawyers may be coupled with clients, particularly in remote areas where courts may be made accessible, where access to legal information and advice may be scaled to help those who otherwise would not be legally supported. Technology and data may assist us to standardise our decisions as lawyers, as judicial officers, as officials within government, within local decision-making fora. That may promote fairness, it may promote certainty, it may help us to be compliant with the law and to support those who need law most. These technologies and the data that underpin it may shed light on some of the idiosyncratic decisions that get made, whether by prosecuting authorities, officials, or even by us at times, when we make decisions which are outside the standard framework, perhaps because we haven't been that well informed, perhaps because we haven't had access to the information we need in order to make good decisions. And it may therefore support access to justice as people are able to challenge decisions which aren't that robust, and for us as decision makers then to be required to justify when our decisions fall outside those that are anticipated in given circumstances. So there are many benefits to the use of technology and the data that underpins that technology. There are also risks, as there always are when there are new opportunities available. There are risks in the context of greater technology use, and there are risks in relying on the data which drives those technologies. So, what are the risks? Well, there are risks that we become overly reliant on the technology to deliver the decisions, and that over time erodes our abilities to think and to reason. Complex decisions require us to have high-level critical faculties as lawyers, and it's something that we seek to develop through our lifetime, our professional lifetimes. If we become unduly reliant on the technology to inform, to guide us, and it becomes a replacement at times or a shortcut to us using our critical faculties, we may become less adept when difficult decisions need to be made. It may also allow us or end with us evading responsibility as professionals for our clients or as decision makers when contentious decisions need to be made. And so we need to think carefully about where responsibility must lie and who ultimately must be accountable for decisions that are made. And it may also, in some contexts, make decision-making less transparent and therefore less appealable. If we do not know in detail the reasons for the decision, it is very difficult to frame an appeal against those reasons. An increased use of algorithmic decision-making may lead us there. Now, Some of these concerns can readily be mitigated and minimised by us as lawyers, as members of the academy, as members of the legal profession. There are ways to frame rules, whether they're professional conduct rules or legislative rules, which make it clear who is to take responsibility, not what, but who, to ensure that there is always a human available in the loop who is personally and professionally accountable for the decisions being made. There are other concerns, however, that are less susceptible to being mitigated and minimised, and that's where we in the academy and in the profession, many of us span both, need to think carefully about how we respond. So algorithms are becoming increasingly important in decision making, in business, in healthcare, and over time also in law. They may be black boxes trained on available data which often replicates the inequalities that already persist within our society. Data which is riddled with the same biases that we as lawyers seek to use the law to eradicate. Just as medical studies are often conducted on healthy men of a certain age because they are a control group, and do not often get tested similarly in the context of women across a range of age ranges. So the legal system is heavily gender skewed in terms of the data we have. The available data that's been collected for lots of other reasons, but not in and of itself to train algorithms. Further, a lack of human given reasons itself will be challenging as the legal system develops, if we become heavily reliant, even at low levels, on algorithmic decision making. The development of the common law is currently the preserve of people, judges, who take into account over time the developing values of society and apply general principles to novel situations in the absence of there being legislation through the legislative system. How will we ensure that the values of those in society are properly embedded in a transparent way in the common law if we become heavily reliant on algorithmic decision making at an initial stage, which may even be a pre-court stage in the context of disputes? Will the common law become the preserve of computer programmers, ChatGPT, and the availability of data, much of which will be, in the end, problematic given the skewed nature of the data collection process? So, at this stage, that sounds a depressing prospect when I have already said there are many benefits to technology and data being harnessed to provide greater access to justice, a standardization of decisions, and to require and allow the requirement that decision makers justify the decisions that they have made. So what is to be done? What can we take as our call to action? What hope can we have that we can influence change? Well, there's a lot. There's a lot we can do. And that is the purpose of your summit. The summit has been designed to harness the intellectual and professional capacity of all of those who have participated to ensure that the benefits of technology and data can be used to promote equality, gender equality and otherwise, to promote fairness, to promote accountability, responsibility, and the rule of law. What do we have within our armoury, within our toolkit? Well, we have our commitment to the rule of law, and we have our commitment to the fundamental, foundational rules of natural justice, which we have all subscribed to. We have the opportunity to ensure that procedural justice is not just considered to be procedures, but enshrining the values behind those procedures, the things that the procedures are designed to protect. Those being equality before the law and otherwise. Ensuring that the law is fair, certain, transparent, decision makers are accountable, that those who come to justice get reasons for their decision, they are able to be heard, they can question not just the evidence put by the other side, that they have not just access to proper legal help, but they have a genuine right to challenge the decision that's been reached by the decision maker with the reasons they need to be able to challenge it. So, I think as your summit comes to a close, we have a restatement of that which motivates all of us to ensure there is equality before the law, protection by the law, certainty delivered through law with fairness, consistency and transparency. And all of the papers and all of the contributions throughout the summit have been designed in one way or another, whether consciously or unconsciously, to deliver on those values. So thank you ever so much for the opportunity to be with you in this very important summit. It tackles incredibly pressing matters in society, and technology and data is there to support gender equality and other forms, and you have contributed to that over the last few days. Thank you very much.
Thank you, Professor Lisa. Many of us are jotting down the notes, and it was a gold dust, I must say. And but it needs thinking, what you said. We will really need to sit down and we'll have to understand. And I have to read again and again to grasp the notion that you just expressed. We are really, the feeling is of an enlightenment, and we thank you for that. But I must say that during the 2-day summit, we have witnessed words of wisdoms, like we just now witnessed, from experts from the field of industry, from legal industry and academia. We have heard Professor Advocate Dr. Prashant Mali, who is the president and founder of Cyber Law Consulting, Advocate Geeta Luthra, Senior Advocate, Supreme Court of India, Islam Meza, Senior Associate at MENA, Dubai, Professor Jay Shankar, who is the founder and Principal Director of Criminology and Justice Sciences, and the International Institute of Justice and Police Sciences, Mr. Neelakanthan, Assistant Vice President Legal at Reliance Industries, Pallavi Rao, Partner Civil Cyril Amarchand Mangaldas, Ms. Prajakta Kale, Professor at Global Jindal Law School, Ms. Hasana Saeed, a professor at Amity University, Dubai. Dr. Soumya Uma, Professor and Director, Center for Women's Rights at Global Jindal Law School. Dr. Neha Mishra, Associate Professor at Global Jindal Law School. Arifa Zahra, Assistant Professor at Amity University, Dubai. Altimesh Siddiqui, Senior Legal Consultant at UAE. Kaustubh Chakravar, Co-Founder of Data Nuance Consulting. Anuj Singh, Advocate at High Court of Allahabad. And wonderful participants. I would like to express our deepest gratitude to Honorable Professor Dilip Upe, Vice Chancellor, MNLU Mumbai, for conceptualizing the theme for the event and giving us all the necessary support for organizing it. My sincere thanks to Honorable Registrar for providing administrative support for executing the event. A special word of thanks goes out to our students, organizing team, for their meticulous planning and flawless execution, ensuring that every aspect of the summit ran smoothly. Your dedication and hard work have been instrumental in making this event a resounding success. Your enthusiasm and passion for the cause of gender equality has been truly inspiring. And to if I have to name the students who have prominently taken part in the organizing team, Vedant, of course, Janvi, Shantanu, Dimple, Aditi, Ria, Parth, Manushi, Ritika, Misha, Shreya, Tatwa, Devashri, Anurag, Gauri, Alisha, Navda, Tanvi Gorakh and Tanvi Mane, Ritoja, Payoja, and Shikha. These students, they have been tirelessly working for last 1.5 months. They are also part of our other events and activities. A special word of thanks to the teaching and non-teaching staff for their unwavering support. And in conclusion, I would like to express my sincere thanks to, most important, the participants who have remained present and have been asking questions to the session experts. They have presented their papers in the summit. We look forward to continuing our collaboration in future with you as well, as we strive to create more inclusive and equitable society. And with those words, I once again thank Professor. It's such a great honor to have you on board. I myself and Dr. Garima Pal, we are very much thankful to you. Thank you very much. We shall share you with the proceedings and the abstract booklet and the other conference proceedings that shall come out soon. Thank you very much, Professor. So with this, with your permission, maybe end the ceremony with the valedictory ceremony. Thank you. Thank you, Professor. Thank you.
Thank you.
Thank you.